you tell the IRA custodian you want to stretch it out. You're supposed to do it in writing. But you do have till the end of the year after the person dies. So if someone died today, the beneficiary would have till December 31st of 2011 to make that decision. Prior to that time, though, you don't want to take the money out or move it, because if you do, you lose your option. So you want to let it sit in that IRA till you make that decision. Don't take the money out.
Well, and again, just be very careful of your beneficiary designation on that, because if you don't have the proper beneficiary designation, or like you say, spouse is, passed away, then that could be the estate, forcing you into a 5-year payout. So beneficiary designees are extremely important on that.
Always beneficiary forms. If someone dies, you want to update your beneficiary form, make sure it's proper. Now, if you have 4 kids and they're the beneficiary of your IRA, they can actually break it into 4s. One child can say, I'm just going to take the whole thing and pay tax and spend it. Another one can say, I'm going to take my share and take it over my lifetime. They do have to break it up by September 30th of the year after you die. And then they make the decision by December 31st. So that's their option. Yes? Same for a Roth. Roth is even better, because you can elect to pull that out over your lifetime tax-free. So if your 50-year-old daughter gets a Roth IRA, she can elect to take it out over a lifetime. Now it's going to keep growing every year tax-free for the rest of her life. Roth IRA is a huge benefit for kids and grandkids. Not so much for you. There is a benefit for you if you don't need it for 10 or 15 years, but the biggest benefit is your kids and grandkids, because they get tax-free money for their lifetime out of that Roth IRA. Huge benefit.
Like my husband and I established a panel right now, so you have 3 children, that's the panel.
Yeah, now if your trust already established the panel. So if you're in the maintenance program, that most likely means your trust is updated. If you're not sure about it, call us. In the trust, part of the trust says this is the panel, so we talk to you about that. Most people pick their kids, but some people pick friends. You just need, we like to have at least 3 people. Sometimes we only come up with 2 because people don't have 3 people they want to use there, but your trust will say that. So trust says in Article 4, if you're incapacitated, your trustee can prove that by a letter from the doctor, or they can use the panel to prove that. Or they can get a court order. I mean, they have all 3 of those options I talked about. The easiest one usually is just using the panel. A lot of times the doctors, as I said, won't do it anyway, so they're forced to use the panel. Yes?
Recently, Idaho legislature was toying around, or maybe they passed it, I'm not sure, about your DNR, living will, medical, people don't have to honor it.
Your living will, they don't have to honor it. What most states say, including Washington, is if your doctor does not want to honor your living will, they have to tell you up front why you're still healthy, as long as you give it to them. So doctors don't have to honor your living will, but if they don't tell your family until you're on life support, that's where the big problems happen. And that's happened before. So if maybe I'm on life support, there's living will there, my wife says take Rial off life support, and the doctor says no, my religion says I can't do that. Now is a huge problem. She's going to have to get a different doctor and go through all this turmoil, and that's not what we want families to do. So Washington State passed a law that says that I could show my living will to my doctor right now, and that doctor has to, in writing, tell me whether he's going to honor it or not. And if he doesn't tell me he won't honor it, he legally has to honor it. That's what Idaho's trying to do, is copy the Washington law, so that you can actually present your living will now and make sure that doctor tells you whether he or she will honor your living will. If the doctor says, well, religiously I can't honor living wills, then you can decide to switch doctors now while you're healthy, instead of putting your family in that turmoil at that time.
What you got up there on the screen about the re-registration,
Yes?
outright versus in trust, does the in trust have to be in the present trust, that wording?
Well, to be in trust, your trust has to say in trust. So your living trust says at your death, either it goes outright to your kids, and that's what your trustee has to do. Then it just pay the bills and they distribute it to them and they do what they want with it. or your living trust says you've established a trust for each child, then it goes into their trust at your death. So that's controlled by how you set up your trust. Remember, we have life plans we talk about in the Living Trust Seminar. Life plan to try to protect assets while you're alive. That's called Life Plan A. Lifetime B is where you set up trust for your kids. That's what that is. So at your death, it goes into those kids' trust. Life Plan C is if you have a big estate where you've set up for the grandkids. When your kids die, it goes into the grandkids' trust. So what you should learn from all this is if there is time to remove a trustee at death or incapacity, you should probably call us. There's a free meeting for your family. So depending on what your trust says and what type of assets you have, how big your estate is, there's different things your family has to do, whether it's your spouse or kids. So it's a good idea. As part of the maintenance club you're in with us, we have a list of your assets, which makes it very simple now because they come in, we've got updated records. They don't have to search through your stuff to figure out what you own. We have records. If you update that every year when we send out that letter to you, we can keep a current record. It makes their job so much simpler because now they just walk in and we have everything right there. If you haven't seen us for 10 years, you're not part of the maintenance program, then your kids, for us to give them good advice, they got to round up all your assets and bring them into us so we can see what you own because our information will be outdated. So that's one of the benefits of being in this program is we can keep an accurate record. And you know your trust is up to date because if you're in the maintenance program every year, we update it if there's a law change. So we make sure it's up to date so we don't have HIPAA problems and all those different things that happen to some of our clients. No, your trust, there is something in the handout we gave you. There is a provision for a special code